Good afternoon. I just wanted to discuss business succession planning. So your business will die with you if you don't plan ahead. So this is most important for solopreneurs, people who work by themselves, whether it's in a solo member LLC or a DBA or S Corp, doesn't matter. If you don't plan ahead and something happens to you, your business will likely not get past it. So I recently had a client come to me whose partner had passed away unexpectedly, and they had not formalized the relationship. So the partner who had passed was the 100% owner of an LLC, and the LLC held title to everything, the bank accounts, the lease, all that sort of stuff. And they didn't have a partnership agreement, they didn't have a buy-sell agreement, they didn't have a limited power of attorney, anything like that in place that would allow the other, or the survivor of them, to take over in the event that something happened to the owner. So the person who passed had a son, and when you pass away and you don't have anything in place like a buy-sell or anything like that, your estate is going to own the LLC membership interest of your business. So that's not great for your business because it doesn't allow anybody else to take over for you immediately. So if you're employing people, if you have regular payroll, if you have people who need to sign contracts, or if you need to sign contracts directly with vendors, or if you need to execute a lease, those sorts of things, your family can't immediately do that for you. If they're even the people who would take over for you. You know, sometimes your family doesn't want anything to do with your business, or maybe they're not skilled or don't have the license to do it. You know, lawyers in particular, dentists, physicians, if that's a professionally licensed profession, then your family can't take over for you. You have to have another lawyer, another dentist, another physician that can take over for that practice, or the practice dies. So the way we get around that is through what's called buy-sell agreements, or something that's carved out in a partnership agreement if it's a business that's owned by more than one person. So whether that be a shareholder agreement, an operating agreement, a partnership agreement, depending on the business entity, you're essentially setting out what should happen after you pass or after one of the partners passes, and how the interest of the deceased partner is being conveyed back to the company or back to the other partners by either the estate of the deceased partner or prior to the estate even receiving it. So what that also allows is for the family of the deceased individual to benefit economically from the interest of their loved one. So the way we do that is usually through life insurance. So if you have a company that's worth $1 million and you have two partners, each of their interests are technically, a bad valuation metric, but about $500,000 a piece. So if one of them passes, their interest should be worth $500,000. So what we do is each partner will get life insurance on the other, and upon the death of one of the partners, it'll pay out the life benefit, or the life insurance death benefit rather, to the surviving partner to buy out the interest of the deceased partner and give that money to the partner's family. So what that does is two things. It allows for your family to be protected long term, and it also allows for the continuity of the business to be maintained. So the day-to-day continues to happen. There's still someone left behind. So you may be saying, well, what about the people who aren't in partnerships? Well, then you have a couple options. You can either have a buy-sell agreement with someone who you're not currently in business with, but who may be interested in taking over your business should something happen to you, where they'd be in that same situation if it were in a partnership, but you just aren't doing business together currently. Or you can set things up to transition to your family right away, instead of through the probate process, so that if you have someone in your family who's able to take over the business, if you're like a tradesman of some sort, or you just own a business that sells products, your kids or your spouse can take over that for you immediately and continue to employ the people you employ and pay the bills that need to be paid and those sorts of things. So if you don't have a plan, none of this can happen. It has to go through your estate, and when a business goes through an estate, the executor or the administrator of the estate has to petition the clerk to be allowed to continue to run the business. Now, that takes time. So it's not something that's going to be like the next day or the next week or maybe even the next month. So you'll have to make that assessment yourself, whether your business can withstand a month of being dormant, or even longer than that. It could be 2 months, 3 months, could be 6 months. Depends on how long the court process takes. But can your business withstand being dormant for that long? Most businesses can't. Mine can't. Most product manufacturers can't. Most professionals can't. So if you don't plan ahead, that's what you can look forward to. And that's what I mean by your business will die with you if you don't plan ahead. Because most businesses, if they're not cash flowing within a week or two, they're done. I mean, you might as well shut them down, and there goes all of your employees, there goes all of your clients, and it's unfortunate, especially in unexpected events where there's no heads up. So the better thing to do is to get with an attorney and plan these sorts of things ahead of time. And the way I do it is to make it part of an overall comprehensive planning strategy. So it incorporates your estate planning needs along with your business planning needs. So get on it. It's important for everybody involved.